This hearing starts with one of the oldest courtroom clashes in the book. A defendant convinced the system got it wrong, and a judge focused strictly on procedure. The question is, when someone says the charge is fake, how does a court actually handle that?
Fraudulent charge. I was on.
Well, I'm not going to say, hey, wait, hold on. There's always two sides to a story, right? There's your side, and then the other person's side. I'm not going to make a decision on what. I just look to see whether there's enough evidence to go forward, and we have a jury determine whether there's enough to convict you or not.
I was arrested de facto on April 20th. De facto, and I was charged with.
Not de facto. You actually were arrested. It's not de facto.
And I was charged with failure to identify. I was taken to jail for failure to identify. The DA could not accept my charges for 24 hours, and all of a sudden,
Studio microphone, and there it is, the classic courtroom cell phone. The judge literally reminds him of his right to remain silent, because every extra word can become ammunition later. Pro tip, arguing your entire case at first appearance almost never ends well.
Hold on. Mr. Matthew, you have the right to remain silent. Don't. I can give you a lawyer now, but I have a DA here, two of them. Whatever you say, they're going to try to use against you. Just now it's not, but it isn't fine. It's not fine. You're only hurting yourself. I'm telling you.
I was not arrested for trespassing. I was arrested for.
You're charged with trespassing, right?
It's a trespass, Your Honor.
Okay.
I was arrested for failure to identify, and I was taken to jail on that failure to identify. The DA could not accept my charges for 24 hours, and then all of a sudden, I was called within Roof 3 up in the jail, and I was tricked into signing a general bond.
That's not a trick. That's to let you out of jail. It's a general order bond.
I was
to let you out.
Paperwork, right? And then I was told to sign for a general bond. And then after I signed, I was told it didn't go through, sign again. And that's when I signed a different signature, the same signature, but a different separate attempt. It shows on the paperwork that this is two separate times having signed. And the second one is the one for this situation, the cause number situation. And it says on my general bond that I am here for a misdemeanor of criminal trespassing, which I wasn't arrested in. I was arrested for failure to appear, which I didn't fail to identify, which I didn't fail to identify because I did identify.
So, Mr. Matthew, hold on. I wasn't there. I don't know what happened. All I'm telling you is you're not charged with a failure to ID. You're charged with criminal trespass.
Right, and that's a fraudulent charge. And what I'm saying is now you are putting me in a position to be arrested having been fraudulently charged.
Studio microphone, this is an important legal distinction. The judge is not deciding guilt here. He's only deciding whether enough evidence exists to move the case forward. That's probable cause, not proof beyond a reasonable doubt. Big difference.
Now you're giving me a court date, which I can miss, and then you will issue a warrant for me based on a fraudulent charge. So that's what I'm saying.
I know that you're saying it's fraudulent, but there's other people that are saying that it's not fraudulent. And there's no meeting of the minds, so that's why we have jury trials, Mr. Matthew.
Yes.
I'm not going to dispute this with you. Listen, you're charged with criminal. I'm not going to debate this with you. Great. Then we will have a jury trial for it. But I'm not going to argue with you. You're charged with criminal trespass. The only thing I'm telling you not to do is don't go back to the law library, to this place where they're alleging the trespass occurred.
Studio microphone. Okay, the lottery numbers line? That's the judge's way of saying, trust isn't evidence. And honestly, imagine if court worked like YouTube comments. Source, bro, trust me. Absolute chaos.
That's it.
So you're not reasonable, right? Because I'm fraudulently charged in the first place, and now you're putting.
Hey, hold on.
Where I may be arrested if I don't come forth.
Mr. Matthew, how on earth would I know that it's fraudulent? How would I know? Am I supposed to take you for your word? Am I supposed to just believe whatever that comes out of your mouth? You could tell me you're the Queen of England. Am I supposed to believe that? You give me the winning lottery numbers. Am I supposed to believe that you got the 6 winning lottery numbers that I'm going to hit $30 million? Am I supposed to just believe? Imagine if every single person that came here, about 1,000 people every other week, am I supposed to believe every single thing that comes out of their mouth? Do you see my point?
I don't have any argument.
This is why I'm telling you, this is a court and we work on evidence. We have people that come testify. We have body cameras. We've got 911 tapes. It works on evidence. And hold on a second. Before anything happens to you here, you will look and you will see absolutely every shred of evidence that they have to prove the case against you. Nothing is going to happen to you until that point. The only thing I'm asking you to do at this point is don't go back to this place and just come back to court. That's all I'm asking you to do.
And that's exactly my point, sir. You're asking me to come back to court, which if I don't, you will issue a reward for me.
Correct.
For my vessel, for my body.
Correct.
Not having committed any crime and having been fraudulently charged in the first place. That is a crime against the state.
I think, given what the state has said, that there's enough probable cause to go forward with this case. And that's it. I understand that you think it's fraudulent. I'm not going to sit here and argue with you because you're not going to accept it. You're not going to take anything I'm saying, and that's okay. But I'm not going to sit here and take another hour and a half to try to convince you.
Studio microphone. That Afro joke? That's classic courtroom pressure relief. Judges sometimes use humor to lower tension while still making the rules crystal clear. Stay away, stay in contact, stay out of trouble. Simple instructions, huge consequences if ignored.
This or that. It's just not what I will do for you now. Listen, what I will do for you now. If you want, I can give you a lawyer. You can talk to the lawyer. As long as you stay in communication with the lawyer, I will waive your appearance so you don't have to come to court every single month. And when this person has all of the evidence that state says that they have against you, you guys can meet and you decide on what you want to do. That's it.
Sure.
So literally all you have to do is stay in telephonic or textual contact with this lawyer. And as long as you do that and stay away from this place, we are all happy. I don't think you can get any easier than that. I mean, all you need now is a damn bathrobe. Really. It doesn't get any easier than that. Just stay in contact. Don't pick up any new cases. Do you understand?
Sure, sir. I will keep in contact with the lawyer that you provided me so I don't have to be present here.
Correct. But when they call you, eventually you might have to come back. So at that point, just be ready because you might have to come back at some point. If they decide to dismiss, then you don't have to come back. But if they don't decide to do that, you may need to come back.
Yes, sir.
Just beware. Do you mind appointing a lawyer?
Yes, Judge.
Do you mind filing those conditions?
Yes, Judge.
Okay. Good morning, Mr. Elder. Sir, you're charged with 2 cases. You're charged with criminal trespass and terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 20th, 2026, in Harris County, Texas, officer was dispatched to a disturbance call. On scene, defendant advised he came to the location to speak with his mother, but had been told by hotel staff he was not allowed on the property and was instructed to leave, but failed to do so. Complainant, the manager, advised she had recognized the defendant and told him he was not allowed on the property and instructed him to leave. Defendant remained on the property despite multiple directives to leave. Complainant then advised that defendant threatened complainant, stating, quote, "I'll beat your ass," while approaching her. Complainant reported she was in fear of imminent bodily injury. Witness, defendant's mother intervened, telling him to leave. The defendant instead put his hand on her face, pushed her backwards, and said, quote, "Call the police. They're going to have to make you leave because I'm not leaving."
So where is this place?
It's a hotel, Your Honor.
Which hotel? Mr. Elder, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're not to go back to this place and not to have any contact with the complaining witness and the terroristic threat. You understand? If you violate these conditions, I will order your arrest, put you in jail. I will revoke your bond. I'm going to make it high. You know, I don't know who you have in this life that's ready to come to bat for you. But if you violate these conditions, you endanger my community. I can revoke your bond, make it $10,000, $20,000, $30,000. And if you don't have anyone to pony up that kind of money, you'll be stuck like Chuck with me until who knows how long. Do you understand? I'm not asking much. I want my community safe. And it takes one thing: self-control. Do you understand? How old are you, sir? How do you support yourself?
Start my job.
Okay. We will appoint your lawyer today, but I'm telling you, it's thin ice. That ice cracks, your butt's going to freeze. I'm going to have you go to Victoria, sign a reset, and then I'm going to have you take a seat in the jury box. I need you to fill out an application for me, and then assuming you qualify, then I'll have you speak to someone here momentarily. I'm going to give you an application. So no contact, no weapons, no going back.
Yes, Judge.
Okay, the sign in just a.
Good morning, Mr. Gold.
For judgment, question.
Yeah, who you got?
See, the first, John Garcia is, we just found out, he said to get a drug test.
Okay.
We're taking some evidence. If it's, if it's negative, I'll just get a reset as possible.
Sure. Yep.
My other is a walk with Deja Bar. You should have PSR in front of you with FSGI.
No, there we go.
I don't see.
Thanks, sir. Do you need a cause number, Farrell, or you got it?
Already.
Okay. Barfield, come up. All right, good morning, Ms. Barfield. Ma'am, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On April 11th in Harris County, officer dispatched a two motor vehicle accident. The complaining witness advised he was at a red light on FN 1960 when an unknown motor vehicle collided into his from the rear. Complainant exited his vehicle to check. Sole operator of the other vehicle appeared to be lost and unaware of what happened, exited the motor vehicle, and then got back in and drove away without attempting to provide any insurance or motor vehicle information. The complaining witness found the license plate of that other vehicle left behind, stuck between his rear tailgate and the bumper. Estimated cost to repair is more $500.
You didn't prove it's her.
Studio microphone. Now this is what fairness in court looks like. Notice how the judge challenged the prosecution for stronger identification evidence before moving forward. That's not taking sides, that's due process in action. Court isn't supposed to rubber stamp accusations.
How do we know it's her?
Officer conducted a vehicle inquiry through TCIC and NCIC on the plate and return came back registered to the defendant.
Great. How do we know she didn't lend the car out? You still need to prove it's her, though. I mean, did the other driver see her?
Yes, sir.
Say that's her?
Yes, so the
Did you say that? Did I
other
miss
driver
it?
said that, observed the driver of the motor vehicle, exit the vehicle, get back in, and then leave.
They observed her.
From the DINs, that's what my gathering is, yes. Judge, I'm hearing articulable facts on how the driver identified my client and then confirmed it with the police. I didn't get the
Well,
second.
yeah, I mean, tell me that he saw Miss Barfield and she's the one that was in the accident and then took off. Right, I get it, it's her car. There's no dispute it's her car, but it could have been, you know, the Wicked Witch of the West that was driving the car.
Right. Okay, Judge. The complainant also was able to identify the driver's license plate return of the defendant who struck his vehicle and fled the scene.
There you go.
Sorry.
Okay. All right. Ms. Barfield, I'm going to find that there's sufficient. I'm just, you know, what's fair is fair.
Absolutely.
Right. Ms. Barfield, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person and not to drive unless you have a valid Texas driver license and liability insurance. And if you're in your name, if you don't have car insurance, then you are not allowed to drive. You understand? Do you mind filing this condition? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, I will revoke your bond. No more PR bonds. This is not a revolving door. If I have to put you in jail, It's no more PR bonds. Do you understand?
Studio microphone, and this might be the hardest truth in the entire hearing. The justice system gives warnings, second chances, even third chances, but eventually the pattern becomes the sentence. At some point, every defendant hits that moment where excuses stop working.
That said, you guys have any requests?
By you saying no more PR bonds, I'm assuming you're granting a PR bond, Your Honor.
Good assumption.
Thank you, Judge. That was
Okay.
my request.
Yeah, so we'll set the bond at $100. I'm gonna grant you a PR bond now, but it's, one, and then another, and then another, and then another, right? Okay. Okay, so for now, I mean, there's gonna be a walk for you to unlock, and a lot of paperwork for you to sign. We have you sign a reset, then we'll have you take a seat in the juror box, so we'll get all the paperwork after that. Once you sign all the documents, at that point you'll be free to go. Okay, thanks.
Right this way.
There's conditions, it was just.
Yeah, just no contact with the complaining witness, no driving without a license, and insurance. Let's see. There we go.
This is Mr. Spark, Your Honor. You look at Thompson.
You don't have to tell me. We know Mr. Sparks very well. It's unfortunate that Mr. Sparks is just another statistic. At some point, you're going to get it. I hope that you've gotten to know the old timers in jail so you see what it's like. Those people who've been sitting there day after day, year after year, in and out of jail, have not even a pot to piss in, no money to their name. As soon as they get out, they ain't got no game, no money. It's not a great life to live. And here you are, 19, in and out, in and out. Now you got a case in another county. I mean, when does it stop? We tried to do everything in our power to try to get you to see, to at least do something worthwhile with your life. Here we are, over and over. You were placed on probation for the unlawful carrying of a weapon. Is it true or untrue that you violated your probation? I'm going to find that it's true. What do we? I see 86 days credit, but what?
Oh, and then should be fine. I have to be a judge. So I guess you can say. It's 86 days with 86 days credit.
Okay. I'm going to send you to 86 days in jail. I will give you credit for the 86 days that you have done. Any weapon that was confiscated in this case will now be forfeited to the state. You will not get it back. All right, sir. Good luck to you.
Yeah.
Thank you, Mr. Vaughn.
Thank you.
Hi, Allie. You ready?
Good morning.
Hey, what's up?
I'm approaching on Darius Morris.
Jail or bond?
Bond.
Oh, that's this gentleman?
No, that.
Someone else. Okay.
It's a motion to adjudicate. We're just approaching to see if you might have any thoughts as to what you want to do with this case. It's really all the way
Yeah.
to be 14. While the patient, he was reported to the unit that tested positive for marijuana. We stopped reporting in June of 2015. And it's like we found him again in 2023 because he picked up a carbon tablets and fell inside me. And then he stopped reporting again.
Can you run an NCIC?
Yes, sir.
What kind of life has Mr. Morris led?
Yeah.
Since 2014, the only charge you picked up was the failed ID in his Johnson.
What do you think? What are you thinking, Stinking?
I mean, just looking at the motion, he hasn't completed anything.
So what's appropriate? What do you think?
I believe that unsaturated would just be a slap on the wrist.
Okay.
I would ask for. I'm sure. Judge, you would ask for an unsaturated.
Well, no, he's gonna have to plead true, right? Yeah, okay. Yeah, I mean, there's an affirmative finding. If he picks up another one, he's looking at the felony offense.
I think that's.
Yeah, so you go ahead and write it up. We'll do, is the failure to ID still open? Do you know? Ally, is it still open?
It's not a business.
Okay, so just, I guess, do you plead to it?
Yes, Your Honor.
So we'll go on that one. Yeah, okay. All right, sure. Hey,
Good morning.
the problem I have, is I understand the health issues. I get it. But I think truly that he's using that as a means to an end. If you look at the report, it says that the alcohol consumption was not during the time he was in the hospital. It was at the time that he was outside of the hospital. So he's still using.
That's the way I.
That's what she told me yesterday. I had her give the report to you so you could see it.
It's not his spike.
I get it.
Part of the time he was in there.
Well, yeah. Part of it, sure. But also part of this alcohol positive was when he was not in the hospital.
I don't reread. I didn't see it.
Give me a second, ask her, she'll tell you,
Okay.
so you can see it.
Okay.
Yeah.
This is I gave copy to the state already. That's his hospital admission bracelet from when he's there now. He's admitted on Thursday. And outside of that, I need you to discharge paperwork. When you get discharged, that will show the entire period he was there and what's going on. That's a copy of the bracelet, the picture from yesterday showing the board, and then his actual diagnosis is there. In that is what that's all about. Now, he also enrolled in an outpatient treatment program. I'm waiting on him to get me some proof of it. Just to show the court that he is sincere about.
When is the discharge date?
He didn't have one. He didn't know.
Because we did the one that's.
Hey, can you do me a favor? I need you to reach out to this hospital to see if he's actually in admittance now. I'd like to know if he's actually in the hospital now. And then, well, no, call the number on the sheet. So we know, please. So there's no, and then I'd like to know when he was admitted, the expected discharge date. And the other question is when they put swabs, I don't know if perhaps they can put you in touch with a nurse or someone there when they're using swabs and the gels for putting leads, is that contain alcohol in it? I don't know if they can know that or whatnot. I may reach out to, I don't know if I should, but can you reach out to them to see all that, please? And then also let him, you said that there was also alcohol detected at a time that he was outside of the hospital as well yesterday, right?
So the alcohol was detected from the 19th to the 20th, and the report that he gave us that he was in the sleep study from the 17th to the 20th. But we cannot confirm if the alcohol was due to any type of medical intervention or.
I'd like to know. So when you reach out to them, can you figure, do you mind asking? Okay, and then let's regroup later. Yeah, okay. So we'll be on standby for now. We need to know what that discharge date is though. Okay. Okay, thanks.
Okay. One more. Okay.
Yeah, who else?
So Hall.
Okay.
Was supposed to kind of check in, see if she made it to the Harris Center. I'm waiting on proof. She is at the Harris Center. I'm waiting on her to get me.
Okay, yeah, usually they will send some kind of proof to someone. Who do they send it to? When we send people to go do those mental health, where they take them to the center, we usually get, I think you guys get some kind of.
Yeah, I'm looking now, Judge.
Yeah, of course. So, hey, if there's no proof though, no waived appearance though, okay? I'll waive it if there's proof. Okay, hi.
Look, this is Justin Stewart, I think, there, who just waiting for contract, right?
Kenneth Henry does not have a contract received, but defense counsel emailed it to him with me at the table.
But I sent it to him, yes, he got it yesterday, but we sent it to him again.
Is everything else but the signed contract?
Where's the signed contract now? You guys have it?
No, I didn't.
Sorry?
I can print it right now to get some, let me print it out.
Where do you have it?
This is my, I have it in my email. But
You want to email it to Kenneth now?
We just did that.
Oh, you did? Okay, so I guess let's set it maybe a couple days for you guys to file the supervision order.
Okay.
He's got the interlock, pay the DA fee, right?
All that, everything is.
Okay, so if you want to maybe set it for 2 days, 3 days for them just to get the supervision order, and then I'll waive it, his appearance, so you don't have,
I think.
yeah, of course. Hi, Corey. Good morning. What's up?
Trina Morris.
What the hell? These bond violations, man. Okay,
Good news.
Morris.
Morris doesn't have any bond violation.
Wait, which, okay, just want to reset?
Yes, recess is fine, but I'd also ask the court for clarification on the bond condition.
Okay,
The complainant is no longer living at the residence of the marital house. He's in job court and moved to training in Utah. So I just want to make sure that Ms. Morris can go back to her home.
I'm okay with it. They need to verify it though, and then assuming they verify that they say he's gone, and then I guess, do you mind reaching out and then also ask how long are you going to be gone? When you do come back, where are you going? Are you going to go back to this house? Or are you going somewhere else? So we need to know if is it a house or is it an apartment?
It's a house.
Who owns that?
My client and her wife, and then there's two children who also live in the house.
Oh, that's right. It's that case. So the partner left?
No, she's still living at home. This is a case my client's alleged to have told her.
Yeah.
Right. My client's wife is still living in the house with the other two children. My client has been living with her mother, I believe,
Okay.
and since we were.
Yeah.
She's were imposed. Of course, my client would like to get home. She also, misses her son, and the complainant in this case would like to stay with him. So also, the court could amend that to threatening harassing.
I don't know. I mean, so
And to give you a little update, CPS closed the case. They found no reason to believe. My client has also completed a parenting course as instructed by the magistrate.
the complaining witness is the partner.
No, the complaining witness is a child. It's my client's.
How old is
Adopted.
and how?
16 or 17.
Okay.
So,
Do you mind reaching out to them to figuring out what his opinion is? Is he okay with it? If so, are there any conditions that he'd like in place? And then let me know.
Yes, sir.
Corey, let's do the writ. Let me figure out what they want, and then I honor what complaining witnesses want,
Sure.
So,
Thank you.
for sure.
It's McLaughlin, NSD, LND.
Mr. Perkins,
I'm sending you.
Good morning.
hey, how are you?
Mr. Eduardo Alvarez, I have the case numbers you need. He's on today's docket. He's in the jury box.
Are you signing on to the case?
I've already signed on the
Great.
case. We've got
He's
recess.
with you. I don't need him.
The question though is he wants to travel in May to Mexico where his father is. Is it funeral or something related to his burial? And that's on May. Pretrial said I should approach.
Yeah, I'm okay with the travel, but just advise him not to use. He's going to get tested as soon as he gets back. If he does, then
Needs anything in writing?
no. Just let her know, just so that they don't call him while he's gone, but let him know as soon as he gets back, he's getting tested.
Yeah.
Not
I'll let
to
him
use.
know to let pretrial know.
Yeah,
And is he free to leave the?
well, he needs to sign conditions first. But yes, yeah, he's free. He can go with you. Yeah, he's not free to leave yet.
Thank you.
Ready? Hi, good morning. Come on.
I'm here on Timothy Williams.
Okay.
I was going to the approach of the agent of the case to CWY.
Yeah, you're at 180 days.
Right. So we're still waiting on a top report. And an offer.
So, I think HOSC have tested the blood and they said they're doing additional tests. We haven't got anything back yet. I just emailed them right now to get an update on it.
And they got the blood and alcohol content back. It's, I think, 0.0 or something. So there was no alcohol.
Yeah, that's why they usually send to the talks. But my problem is, did you just now send it to the talks? When did you send it?
I sent an email today.
I know you sent an email, but when did you send the blood to the talks place? Because that usually takes another 6 months.
So the tox report we have said that the sample has an additional threat for toxicology that has removed. So they have the blood.
Yeah, but, so, Farwa, they get the blood, they put it in line. The problem is that it'll take 4, maybe 5, maybe 6 months, maybe 2 months to test the blood to see if there's anything else in the blood. But you get in line at the date that you send it. So if you sent the blood yesterday, and this case is 170 days old, I'm gonna have a problem with that. Because I'm not gonna wait another 6 months for this thing to play out. So if you sent the blood maybe like at 130 days or 120 days or, then that's more workable.
I'm not sure when